presenter is Professor Muruga Ramaswamy. He's an associate professor of law at the University of Macau. He's the area coordinator of services teaching at the faculty, including the interdisciplinary master's program in data science and law, and also he serves as the area coordinator of master's program international law. His research interests include international trade and commercial law, foreign investment law, IT law, data protection laws, and international business law. Professor Ramaswamy, please. The floor is yours.
Thank you, Chair. First of all, wishes to colleagues and friends. Thanks to Professor Wolf for the invitation. I'm very happy to see friends from elsewhere, from China, and also from Hong Kong U, as well as also from CityU. I'm very much honored today to talk about the doctrine of enrichment here in this forum, because among all your experts, I have to start with a little caveat that my field of expertise is primarily in international law, and in this context, I've dealt with the issues of unjust enrichment, mainly from the perspective of several contexts where it could arise, including in the investment disputes.
Professor Ramaswamy, can I just, sorry to interrupt, do you think it's possible to bring the microphone a bit closer to yourself?
Oh.
We can hear you, but not terribly clearly.
I'm sorry about that, Chairman. Is it better now?
Oh, it's much better. Thank you so much.
Thank you.
Sorry to have interrupted.
That out to me.
My apologies.
Not at all. I should apologize. Rather, I just not been able to see how it sounds before. In terms of what I intend to present today, I just want to briefly say that I intend to speak more of what unjust enrichment in Macau during this period, since it's being handed down over from the Portuguese administration, and we are developing our own jurisprudence. So my interest mainly in this context is to see how are we evolving since we became an SAR, because we have inherited this whole concept from the Portuguese tradition, and of course our civil code is highly been influenced by the Portuguese civil code, which is of course originally been influenced by the BGB. And then based on this, we would like to ask certain questions here in terms of my presentation. I'm just wondering about what is its role, and later on a colleague of mine would speak about its subsidiary role more in detail. But my concern also emanates from the subsidiarity of this area of law in Macau, because in my observation, I found that there's almost a non-existent role for this field of law. And I start to wonder whether I could speak about the role of law. I should say more than what unjust enrichment in Macau. More than that, I should be probably speaking what it is not. And in that regard, it's going to be a little bit critical. But I would say that this is required at this juncture, because Macau is transforming itself in a lot of ways to be integrated in the Greater Bay Area, as well as also in other economic partnerships, especially in the Portuguese-speaking context, the Lusophone jurisdictions. And it's a high time we start to look into this field of evolution to see that how we could adapt and also to harmonize to some extent with the neighboring jurisdiction as well as other Portuguese-speaking countries, which is very highly critical. So in that context, I just would like to start with a quote of Dawson, who wrote in 1951 that is talking about the comparative aspects of unjust enrichment. And he has this to say: in a very short space of 75 years, we have created a monster. So he calls this evolution as a monster. Even 1950, when he is comparing this in the different jurisdiction which he studies. And since then, if we see this, especially in terms of what's happened elsewhere in common law, and I'm trying to also try to see in this context what's happening in different civil law jurisdictions, even within the Europe, the Germanic family, as well as also the other influences, the French influence systems, as well as others who have also benefited from these legal systems elsewhere in the world. We see a great amount of diversity, and that's why I think this whole forum makes a lot of interesting role to play. But in my opinion, more than actually this being considered as a monster, as Dawson says, I would say it's an ogre because it's really caused a lot of good in terms of this diversity, in terms of its flexibility, or in terms of its scope, I would say. And I'm referring to this to the equitable origin, very much seen elsewhere, not only in the common law context, but also in the civil law tradition. What the courts have done beyond the civil codes, in a way, how they interpreted and how they developed this jurisprudence over the years, and that is where I think my main interest lies. Having said that, Chairman, let me start with my brief presentation here, which I prepared. I'm going to share the screen. In terms of that, I just have this. All right. So here, my first question, which regard to the role of Macau in terms of its unjust enrichment, is this: Macau mainly proclaims that there is no place for restitution due to unjust enrichment when the law provides the impoverished with another means. Article 468 of the Civil Code very categorically says this. So this subsidiarity of this remedy raises a range of questions, actually, with regard to its scope and limitations, because if it is really a subsidiary, remedy, and to what extent we have actually realized the fruits of it in the context where it should have played a role, and that is where my skepticism arises, and I would later on show some jurisprudence in this regard that the court have kind of failed to utilize this subsidiarity very well. Coming from that, my framework of my thesis is mainly to identify the unique characteristics of the law of unjust enrichment in Macau. So here, mainly this is about the analysis of the normative standards to trace its roots, of course, to the Portuguese tradition and elsewhere, because this still continues to play, because we have not simply followed the Portuguese tradition. There are differences. We have kind of our own characteristics in the Macau civil code, which has to be taken note of. And also to the extent that we have evolved as an SAR, influenced by other things, like what's happening in the region, for example. The influence of the Chinese, developments, as well as Chinese law in itself. So these things are very, very important to be taken note of, and also as the needs of the Macau SAR in terms of some international developments, especially in terms of financial crimes, and especially in terms of certain public law developments, which I'm going to allude to a little later. And here, I'm going to be talking about, of course, this subsidiary, it's really subdued this role, or whether it is invigorated its evolution. That is my question. And here, of course, there is a need to nurture new innovative role of unjust enrichment in the future in Macau, because there are still a lot of gaps and limitations in this fields of private law, and how it's going to play a role in supporting other areas of public law and certain unforeseen situations like what has arisen out of COVID-19 and the impact on our gaming industry, etc. And here, the subsidiarity here mainly is, we are talking about the subsidiarity versus the primary characteristics in the restitution claim. And my main point today is subsidiarity is fine, but what kind of subsidiarity is Macau following? Is it like a weak subsidiarity, whereby the virtue of which we would be able to grant the unjust enrichment remedies in the event there are other remedies are not going to be successful or insufficient? In that context, we would be able to step in and use the unjust enrichment remedy, and that's something which is a weak subsidiary system. But it seems that instead of a weak subsidiary system, we have a very strong subsidiary system here, whereby we are rather emphasizing that even if the other, especially when the other remedies are available, and if those remedies are not successful, still we are not probably going to step in and use this very effectively, and that tantamounts to a very strong subsidy system, in my opinion. And when you make this comparison with, of course, the other systems, actually, it's also very obvious with the common law as well as also the civil law tradition. So here, the intricate question of subsidiarity, the thing has to be dealt with very seriously. That's the main emphasis. But it's not only about the subsidiarity role, but I'm going to go beyond and highlight several of the other concerns which emerges, especially with regard to the CASA, which is a very important element in the Macau civil law tradition, to show the negative element of absence of CASA, so that you will be able to establish one of the important requirements of the unjust enrichment in the Macau law. And then, other than that, we also wanted to show that in terms of how the enrichment itself is measured and how this is used to compensate, if at all it's being used, then that question is also under concern. And I wanted to show that there are some other developments elsewhere which is happening and which Macau is not actually following. And I'm also trying to bring in to see that what is the role of the influence of equity and, of course, to some extent, how this influences Macau. Now, coming to the normativity of the unjust enrichment, Chairman, I'm just going to be emphasizing on few characteristics quickly. And here, of course, the four important requirements which has to be emphasized. But before that, I wanted to bring in a couple of very important elements of the Macau legal system, especially the civil law system. Article 430, subsection 1 of the Civil Procedure Code requires the Macau courts to make a preliminary ruling with regard to that of the facts which has to be essentially proved in the then to fit the remedy or fit the solution which is being sought. So in a way, that preliminary ruling determines the facts, and the parties have to go on to establish and prove that facts or bring the evidential elements to prove that. And here, of course, this is a very interesting, unique characteristic. Of course, it's also available in other civil law jurisdictions, but that's something very, very important to take note, because this is, the judges have a role to determine the facts, and the facts play a very important role in regard to establishing an unjust enrichment claim or the very ground of seeking that. And then the question of other important element to be noted is here the concept of subjective right, which is also embedded in the Macau civil law system. And this is very, very important, because this is also derived from historically from the Portuguese civil code. Here it says that every subjective right has a corresponding action. Here actually it says that the recognition by the courts is very, very important. So in a way, we are talking about the court has a role to play at preventing or compensating the infringement and by enforcing it. And this subjective right provides, a corresponding action for the holder of the subjective rights. And in a way, this is slightly in contrast with the common law tradition, because in the common law tradition, we have the other way around. It's based on the action, whereas here it is based on the subjective right of the individual, and that is something very important. So why am I pointing out to these very important procedural rules is because this, in my opinion, creates an extra onus or responsibility on the judiciary to play a very important role in using this as a tool to ensure that unjust enrichment remedy is used to effectively safeguard the subjective rights, and that is, it's questionable whether the court is doing that or not. And coming to the point of the important requirements, I'm not going to go through this in a very systematic way of all these elements which constitute unjust enrichment. But for the sake of clarity, of course, this would be in consonance with other civil law jurisdictions, mainly with that of the elements of enrichment itself. Of course, here we would see more emphasis is placed on the enrichment. It's not so much in the terms of what is the impoverishment of the individual or even the enrichment, how it is computed. Here, there is a concern. For example, in terms of enrichment, what we see here is it is computed at the value at the time, at a particular given point in time, and it's based on actually a very much on a hypothetical situation of what if the enrichment has not happened, and try to compute the difference and arrive at the enrichment figure. And this is certainly not going to be a very objective one, or it's not based on the reality in a way. So there is an element of concern which emerges here, that this is not actually going to be accounting the real enrichment itself, even if that is to be granted. The computing itself is a question which can be arising. And of course, the enrichment can be in different forms, which I don't want to go. It's a theoretical one. And moving on, with regard to the expense of the third parties is the second requirement. It has to be kind of emphasized that there should be some proof that it has happened that using the resources belonging to a third person. And of course, see here, this is something which also I wanted to repeat that fact that the question of whether an impoverishment happened or not is not a concern in this regard. Then coming to the CASA. CASA is a very important and controversial one. Of course, here one would be able to see that the element of CASA, how that turns out to be in the Macau context. Here I would say that the CASA in this context is more pronounced in the terms of a negative way by saying that should be an absence of a CASA. So in a way, it is about the CASA being not present. And of course, this implies that the ground of CASA did not exist when the transaction occurred, or the thing has ceased to exist as it disappeared. I mean, this is a very important element with regard to proof of the CASA element. And then the CASA in itself causes a number of concerns with regard to certain conflicts with the other parts of the civil law fields, like, of course, including contracts, torts, as well as also property law, and which we will be probably not having time. I will be alluding to that more in my paper. And coming to this concern of that with regard to the last one, which is the subsidiarity principle alluding to the absence of the legal remedy. And that is where here there are a number of things which in Macau context it is put in a very residual role to play. And of course, this is something, in my opinion, or any reasonable interpretation of the provisions would say that it is meant to be soft or a weak subsidiarity, not a strong subsidiarity as one would theoretically perceive this. And but in spite of that, we would see that this subsidiarity is very much pronounced in the Macau law with regard to explicit remedies available elsewhere. For example, in the context of nullity or annulment in Article 279 to 82, if there is a dissolution remedy available in according to Article 427, and of course, there are different types of remedies which are conspicuously made available in the civil code. In that context, of course, this remedy will not be available. But in this, I wanted to classify this into two types of categories because sometimes it is perceived that the use of this unjust enrichment as a mechanism can go against the intention of the legislator himself, or it's about the policy itself, the objective behind the particular legislation, etc., etc. So in this regard, if we classify these different remedies, some of them are more pronounced than others. For example, there are a set of things where the restitution is actually, as a matter of intention of the lawmaker, is denied. For example, in the cases of prescription, forfeiture, adverse possession, etc., there, of course, restitution is denied. And that policy, of course, has to be maintained when, of course, we cannot be under the rendering restitution based on unjust enrichment. That, of course, is very much glaringly conflicting with the intention of the lawmaker. But so far as the other remedies are concerned, the issue is how do you actually navigate around, if at all you consider this, and if there is actually a principle of subsidiarity here, one should not forget that the very principle of subsidiarity itself is the intention of the lawmaker. So when you have this as an intention of the lawmaker, substituted by, of course, not substituted, supplemented or supported by the fact of subjective rights and the role of the court in determining the facts, which I mentioned in the procedural law, the combination of which creates a lot of onus for the judiciary to respect this objective, to ensure that this is, indeed available as a matter of policy or intention of the lawmaker guaranteed. And coming to the issue of the other one, Chairman, I'm also mindful of the time. I probably have a few more minutes, I suppose. So here, I just wanted to talk about a couple of other things. One is about the obligation of the restitution itself when it is being computed. As I said, that the value under which it is being computed is something questionable as well, according to the provisions of the law itself. And because this one does mainly talks about the emphasis is on the enrichment. It doesn't take into account of the impoverishment. Of course, in many jurisdictions, we don't look into that. But there are some evolutions which I wanted to bring into account, which are very, very important to be taken note of. Brazil, for example, in their civil code have introduced an account to be taken into account of the inflation or some monetary adjustments to be made in terms of computing this enrichment, and that has to be awarded. And that is something very much similar with, of course, the Brazilian civil code is influenced also by the Portuguese civil code, and it sits well in their legal system. And coming to the point of the other issue, which is about the prescription. In Macau, of course, we have indeed the limitation period for a remedy in general is interestingly different from that of the Portuguese one. This is one area where we have deferred to the Portuguese civil code. The Portuguese civil code has taken the position of by default, the around 20 years as a limitation period. Whereas in the Macau civil code, this has been drawn to 15, which is less. But then there is a special limitation period or a prescription provided for the unjust enrichment is the period of 3 years. And this is from, of course, the time of the knowledge of that act, plus also the person who has benefited it or the debtor, both has to be identified. But nevertheless, this is a very short period, and of course, in many circumstances, what happened in the Macau context is an unjust enrichment thing, since because of its subsidiary nature, parties tend to sort of not directly seek for it. Instead, they try to negotiate with the other party, etc., on other basis, try to have compromises, and they lose this valuable period because they know the parties, and then if the drags on for 3 years or more, then there is something which has to be done. So I think the time is up. I think that's what the chairman is showing. But quickly, let me come to my final thing to say a concluding statement, and then I stop there, which is mainly about how this has to unfold in Macau for the future, because Macau has bigger aspirations. We are now looking for to have a stock exchange of our own. We are looking for, of course, to revive the gaming industry and diversify the gaming industry, looking into financial innovation. We are trying to integrate with the Greater Bay Area. We are trying to play a more prominent role in the Lusophone countries, etc. So at this context, what happens is the nexus between the unjust enrichment and that of the public law area is gaining a lot of significance. I would like to bring in this very important interpretation issues happening in the US at the moment when we're talking about the Liu case, where the Supreme Court is currently debating on this matter, whether the SEC should be given the power, the equitable remedy to seek for disgorgement of the profits with regard to certain things. In the Macau context, of course, we have introduced a very interesting crime called unlawful enrichment as a crime. And that's something which we don't have time in my paper I'm going to allude to, and we have found the necessity of that. And of course, here, in terms of this one, even if we are not trying to move towards the direction of unjust enrichment, we should still seek to look for unjustified enrichment, as our colleagues have previously alluded to. The last point I wanted to make is, currently, by review of my jurisprudence of the courts in Macau, unfortunately, have shown that in many cases where unjust enrichment has been raised, the court have not even taken care of addressing them, or even trying to go into the crucial arguments. Sometimes it's been raised even much more critically, or much more with a lot of emphasis on them, citing the cases from elsewhere, etc. The courts have not responded well. There's also another recent development where the court has tried to sort of, especially the Court of Final Appeal, has tried to sort of emphasize that the second court, which is trying to use the role of the contract instead of that of the unjust enrichment, and also made the contract, declared the contract to be void, was not a right approach. But the final court did not denied that. Of course, the first court has, of course, used the unjust enrichment. That was a very interesting development. But the Court of Final Appeal has kind of denied that. That's a really unfortunate situation. So it shows that there are a number of cases in Macau where the remedy has been referred to or sought by the parties, but the court has mainly not paid attention to or addressed that point at all. And in that context, the thing has to improve. And I want to go back to my initial point, where the role of the court, by the fact of its preliminary ruling, as well as that of the subjective rights enshrined in our civil procedure code, should enhance its role and be the guardian of the rights of the citizens, even though it is in subsidiary nature. Thank you, Chairman.
Well, thank you so much, Professor Ramaswamy, on your very thoughtful reflections on Macau law of unjust enrichment.